All right, everyone, happy Tuesday. Welcome to the 187 District Court. These are the rules of the 187 District Court. You are in a courtroom. If you do not behave appropriately, your Zoom privileges will be revoked and it will begin to not be such a happy Tuesday, because what will happen is you will be required to appear physically in the courtroom, whether you're out of county, out of state, out of country. You're going to be required to appear physically in the courtroom. To all the inmates, you're not allowed to use the chat box. You're not allowed to use the internet. If you do any of these things, you will be sent back. And as you know, they're shorthanded. So what will end up happening is we may be able to see you anywhere from 30 to 60 days. To the inmates, if you're wearing a mask, that mask needs to cover your nose. Otherwise, it's just a chin strap or it's really useless. And we wear masks to protect others, not to protect ourselves. To all the defendants, your attorney's name will be called, your name will not be called. If you do not hear your attorney's name, it's because your attorney is Zooming in another courtroom or had to appear in person in another courtroom. Just be patient, relax. You will have a chance to have your attorney meet with you today. Mr. Eric Anthony Flores, if you can turn the television set off behind you, that would be greatly appreciated. All right, I'm going to open breakout rooms. When I open the breakout rooms, it will invite everyone to a breakout room. Do not go to a breakout room unless I specifically call you by name and invite you to a breakout room. To the defendants, your client, your attorney is probably going to want to speak with the state before they speak with you. So please do not raise your hand asking if you can go to the breakout room, because if your attorney wants you in the breakout room, your attorney will request that you go to the breakout room. Attorneys, the prosecutors have the ability to move throughout the breakout rooms. Be patient. When you go to the doctor's office and they call you to the back and you are all excited because you think you're seeing the doctor, you're not. They're taking you to a little room and they're checking your weight and your blood pressure. So when you go to those rooms, be patient. If you leave that room, the prosecutor will see that that room is empty and they will skip over you. Attorneys, when I call your name, I need to know the name of your client. I need to know whether or not it's criminal trial division or family violence. If you have the ability to add to your name the name of your client and whether or not it's criminal trial division or family violence, that will make things go quicker. Attorneys, please do not chat, call, text, email Ms. Ferguson, the court coordinator, asking her if you can be excused or if you can have a continuance. I'm the only person who can give you that. If you have a plea bargain agreement with the state, no matter how small you think that agreement is, you need to put it in the chat box to Ms. Ferguson. All right, the order attorneys are Courtney Hilliard, Donald Wilson, Paul Smith, Robert Featherson, and Thomas Hilly. And Mr. Bonk, I know that you are in the courtroom. We will take that matter up shortly. All right, Courtney Hilliard, who do you have?
Good morning, Your Honor. I'm here for Dante Hilliard, and Mr. Featherston is also on the matter as well. It's an MTR.
That's correct, Your Honor. I have his
Criminal trial
number.
division or family violence?
It's both. The MTR is criminal trial division and family violence on one of the new allegations.
All right, I'm sending you both to breakout room number 3.
Thank you.
And a prosecutor will meet you there. Donald Wilson.
Morning, Judge. I've got Mr. Kochansky and it's CTD.
How you spell the last name?
Kochanski.
All right, I'll send you to number 4.
All right, thanks.
Paul Smith, thank you for changing your name.
Good morning, Your Honor. If I could speak with one of the DAs in family violence, Mr.
I'll send you
Tyler.
to number 5.
Okay, thank you.
You're welcome. Thomas Hilly. Thomas Hilly, who's always on the phone talking to somebody else. Does anyone know who Thomas Hilly's client is? Mr. Howard. Mr. Howard, are you family violence or criminal trial division? I will check and see. All right, it's criminal trial division. All right, and are the parties ready on Mr. Curtis?
Stays ready, Your Honor.
All right, and defense, did you follow your motion?
Yes, Judge.
All right, to the clerks, could I? Yes,
Mr. Linwell, I'm trying to find him.
all right, thank you.
Sorry. But if I can't find him, we're gonna proceed.
All right, just let me know when you're ready.
Yes, Judge.
All right, Mr. Smith, you're back.
I am, Your Honor. Tom and I talked, I do need to meet with the family violence people. Tom was CTD, and the family violence case, the aggravated assault, is a new case.
Okay, let me find this on the document sheet.
Judge, I didn't see it on there, but I just looked it up in the system.
Okay, what is the cause number?
The cause number there are two. There's a family violence and there is a new number one. The new number one is CM 92003.
Okay.
Last name Tyk or Tyke, TYK. First name Thomas. And then he also has a probation MTR, which is 2019 CR 8036.
All right, to the clerks, can I get 2019 CR 8036, please? All right, Jonathan Watkins.
So sorry, I was on mute. Good morning, Your Honor.
Good morning. Who do you have?
I have Michael Moreno. This was recalled for a status update on the injury case.
Yes.
Yes, ma'am. Let me see here. And you can hear me okay, Your Honor?
Yes, I can.
So I spoke to John Carla, who is one of the attorneys on the injury team. Yesterday, they did meet with Mr. Moreno. All the authorization forms and some additional forms were signed on behalf of the client. They're supposed to do, and I know that you're trying to get this train moving, Judge. So if you give us a date, we will be fine in accepting of whatever date the court provides. But it looks like they're going to do depositions like early next year. So I mean, that puts us in January timeframe on his civil case. But I do know that he did agree to do some time, and I want to be respectful of the court's docket. So perhaps the court could provide a date, and then I can let his civil attorney know, hey, like, this is the date.
Yes, we're going to do it in December.
Okay.
Yes, so if someone can give me a December, Ms. Ferguson, if you can give me a date in December, please.
Is there any way we could do late December, Your Honor, or maybe right after the holiday?
No, it'll be mid-December.
Okay, yes, ma'am.
All right, we're going to come back on December 14th. There will be no further resets.
Yes, ma'am. Thank you, Judge. And you have a happy Thanksgiving, Your Honor.
All right, thank you, you too.
Take care.
Your Honor, if I may, I had to fix my audio, but it's fixed now.
All right, Mr.
Good morning.
Healy, who do we have?
I have Joshua, and I would like to talk to the state's trial division, please.
All right, I always ask attorneys, what is their name of their client and whether or not it's criminal trial or family violence. 'Cause we have a lot of people on the docket, so you're just telling me Joshua is not helping.
Joshua Howard. Joshua's Wayne Howard, and he's in jail, and I need to talk to criminal trial division, please.
All right, I'm sending you to
Thank
number 2.
Thank you, Honor.
Mr. Cox, who you have?
Morning, Judge. I have a Raymond Amaya, Amaya.
Criminal trial division or family
Criminal
violence?
trial, I'm sorry, criminal trial, Judge.
I'm going to send you to number 6.
All right, thank you, Judge.
Everyone, just give me a moment.
ID.
No, you want me to do it again?
I'm muting myself.
All right, everyone, just give me a moment, please. All right, so on Thomas Tick, State, how much time do you need?
Judge, the new number 1, family violence, I was looking at it, what we just have the warrant, the CM warrant. So we don't really have a report or anything else. So let me see. The alleged offense date on this case would be the 21st of October, or 20th of October. We would ask, I guess for a couple more weeks at least to get that prosecution guide or report or something that we can go off of.
All right, Ms. Ferguson, can I have a date for Mr. Tech, the second weekend of December, please? All right, we're going to come back on December 10th.
Well, Your Honor, may I be excused?
Yes.
Thank you.
Thank
Y'all have a
you.
great holidays. Bye-bye.
All right, you too. Rick Ramos, who do you have?
I have Mr. Williams. It looks like he's 14. Oh, Your Honor. And that'll
All right,
be
what's his full name?
Ira Bashan Williams, IRA,
Criminal Trial Division or Family Violence?
Criminal Trial Division, Your Honor.
All right, I'm seeing you number 5.
Thank you, Judge.
You're welcome. What's the update on Dante Hilliard?
Judge Robert Featherston here. We've discussed that with Michelle. They're going to go ahead and terminate unsat on his less than a gram case. And I'm going to go forward on his violation of a bond protective order case and ag assault case. And if the court would allow it, I'd like to get in a breakout room with Dante Hilliard and also attorney Courtney Hilliard.
All right, so is that being taken care of today, State?
Yes, I just actually signed the motion to withdraw. The night mag cases are still in intake, and I just emailed Marissa and our CVL about them, but we'll just treat them separately.
All right, thank you. So if you all can go to breakout room number 3.
Thank you, Your Honor.
You're welcome. Everyone, just give me a moment.
Judge, when you get a chance, could you put, his last name is Howard. He's in custody in breakout room 2. His lawyer is already in there, please.
All right, Mr. Howard, if you can go to 2. Mr. Hilliard, you're already assigned to breakout room number 3, so you can go there. All right, are we ready on R.C. Curtis?
Yes.
And here we go, Brenna. Brenna, I do believe, I'm thinking it's you. I'm thinking it's you.
She's not coming. Are you coming out here?
No. Brenna.
Let me see if I can do it. Oops,
It's Monday. We're going to see. It should happen. We're going to put patience in our pocket. And why would Tom pop up? He's on mute, right? So let me see. Oh. It's there. How that happened, I don't know. All right. Just 1 second. All right, the court is calling 2019 CR 10230, State of Texas versus RC Curtis. Can I have parties announced for the record for the state?
Darrell Harris for the state, Your Honor.
For the defense?
Charles Buck and Richard Lengwa for the defendant RC Curtis, who is present on Zoom.
All right, and also for the state is Stephen Spear, is that correct?
Yes, Your Honor.
All right, we're proceeding by Zoom because of the pandemic. Any objections to Mr. Curtis appearing by Zoom? State?
No, Your Honor.
Defense?
No, Judge.
Mr. Curtis, can you unmute yourself for me, please?
Yes, ma'am.
Yes. Do you have any objection with this hearing taking place by Zoom?
No, ma'am.
All right, thank you. If you ever need to respond or would like to respond, Mr. Curtis, if you'll just raise your hand, then I will acknowledge you, okay?
Yes, ma'am.
The defense has filed a motion to reduce bond. State, have you had a chance to review the defense's motion?
Yes, Your Honor.
Did you confer with the defense in regards to this motion?
Yes, we did, Your Honor.
And are you in agreement to reducing the defendant's bond?
Your Honor, I would agree that there may be a reduction in order. The issue goes to where it would be set. Counsel and I could not agree on.
All right, I'm gonna need you to speak up.
Your Honor, while I can agree with the time of the offense that there may be a reduction in order, it's appropriate. Counsel and I could not agree as to the amount.
So is the state in agreement to a bond reduction? I'm not speaking of the amount just yet. Is the state in agreement
Yes, Your Honor.
that the bond should be reduced?
Yes, Your Honor.
All right, state, what are you asking that the bond be reduced to?
Cut it in half, 350,000, Your Honor.
All right, state, why are you at 350,000 and why only half?
Your Honor, principally because of the defendant's demonstrated non-conformity with bonds at the time this case came about and the initial bond was set, and then the facts and circumstances in the allegation of this case.
What are the issues with bond? Because everyone knows this case is from 2015. This court did not have this case. It did not originate in this court. It originated in another court. And then this court, when this case was sent to this court, we were already in the year 2000, I believe 2020. So the court is not aware of any prior concerns or issues with Mr. Curtis being on bond. So has Mr. Curtis ever been on bond in this case?
In this case, Your Honor, not since arrest.
So he's never been on bond. So when the state says that there are some issues with this conformity with bond, you're not speaking of conformity with bond as it relates to this case?
Not directly to this case, Your Honor. Actually, I was referring to the defendant's past history with a previous bond in another matter, which is what brought him into the state, led to his initial arrest on October the 27th. In that case, he had been a fugitive on a different charge for a matter of 322 days. It was only brought into address when he was picked up on a warrant for the facts and the allegations of this case.
All right, when you say a fugitive, are you speaking of fugitive on this case?
No, again, Your Honor, I was referring to his nonconformity with a bond in another matter that was identified when the defendant was identified as a suspect in this case. He was arrested on that warrant for the other case. He had been a fugitive for 322 days. And he also gave a consensual statement to authorities about this case. And then he was arrested for a related charge in this case.
Now, well, I want to be sure when we say fugitive, sometimes someone is a fugitive and they don't know they're a fugitive. That's what I'm trying to get out. So my question is, was he taken into custody and then became a fugitive? Or was something filed against him at large and he did not know there was a case pending? That's what the court is trying to get at.
Yes, ma'am, I understand. And I can, from reviewing the record in that matter, for the record is CC 434104 out of the County Court 1. The defendant had been booked on it in August of 2014. And he had a violation report filed in December of 14 with a warrant out for his arrest that was finally executed October 28, 2015. And I would only note that the court says he doesn't know, the defendant knows he needs to check in with his pretrial services. CC 434104, theft by checking County Court. And my only point, Your Honor, is that is the warrant by which the defendant was brought into custody. He was a fugitive for 322 days at the time.
All right, defense.
That was a theft by check case. And for the state to assume that my client knew what he was, that he was supposed to report to pretrial services or what have you, that's an awful big jump. Nonetheless, his bond was what, $300. So to say because he didn't miss court. It's not a situation where I'm looking at it now, he didn't miss court. That I can see, he had a pretrial issue and a bond increase that, as this court is aware, if there's a bond increase, nobody necessarily notifies the defendant that there's been a bond increase. So for the state to say the defendant knew he had these issues, I think that's a very broad leap, if you will. Nonetheless, he's been in jail 2,123 days that I'm aware of on this case at a $750,000 bond. And now the court is aware, the state has evidence, and it's entirely likely, and in fact, it's possible and quite likely, he didn't even commit this crime. So I think a bond reduction is absolutely justified. I think it's insulting to say, let's set it at $350,000, knowing what they know, knowing how long they've kept him locked in that cage. We're asking the judge to set the bond at $1,000. If the court needs evidence of his indigency, Mr. Curtis can provide that evidence. I think the court is aware that he doesn't have it, anyway, he didn't have anything. He's broke, he's destitute, he's indigent. And the delay, as I said yesterday in my oral request for the bond reduction, this delay is not due to anything he did, anything. He's now looking at a delay of possibly months and months for the trial so the writ can be heard. And the defense can now prepare for the obvious defense of the fact that we know he didn't do it. The purpose of bond is not to keep somebody in there after the state has withheld Brady information, has withheld discovery. And there's no evidence he's a flight risk. There's no evidence that he's a risk to the community at this point. In fact, there's evidence he's not, in fact, the risk to the community that they thought he was. So we're asking the court we asked yesterday for a PR bond. We asked that knowing that this court currently has individuals on capital murder on PR bonds. We don't think that's out of line actually, but in the alternative, we're asking for you to set the bond at $1,000. Like I said, if the court needs evidence of its indigency, we'd be glad to have Mr. Curtis testify for that purpose only.
All right, and as defense counsel is where, in those cases, the law required that they receive those bonds. With regards to this case, is there any other argument from the state with regard to a bond reduction? The court is going to grant a bond reduction. The only issue is the amount of bond.
Yes, Your Honor. And if I may, in just brief response to counsel's argument of the existing bond, and as the court's noted, the state agrees that a reduction may be in line. The defendant's mere inability to meet the bond set does not automatically render the bail excessive. I cite Ex parte Brown, 959 Southwest 2nd, 369. Factors for the court to consider in actually setting the bond. I note the aggravated circumstances involved in the defense. I cite Smith v. State, 829 Southwest 2nd, 885. Under the circumstances of this case, as has been known and neither party can dispute, 75-year-old Paula Boyd was found brutally beaten in her home on October the 21st.
Okay, here's the thing, the court, not to interrupt, but the court realizes all of that. But where we are is, this case has been pending since 2015. I gave several settings in this case.
Yes, ma'am.
On September 27, 2019, discovery acknowledgement was signed.
Yes, ma'am.
On October 21st, 2019, motion to adopt the state's previous motion was granted without objection. Motion to disclose experts granted without objection. State then finally in 2019 said they would not be seeking the death penalty, although this case had been pending since 2015. December 6, 2019, the attorneys were to return on December 9, 2019 to hear motions. March 3rd, 2020, motions heard. March 4th, the 702-705 hearing. September 28, 2020, hearing rescheduled, defense not ready. There was some kind of miscommunication over dates. October 12th, recall. The defense objected to the Zoom hearing. So then November 18th, we did a test run on everything for the hearing on December 2nd at 1:30. Motion for continuance was granted. December 4th, 2020, continuation of hearing on the 702-705 hearing. December 11th, recall for December 15th, unable to review State's Exhibit number 8. December 15th, defense attorney Langlois unable to Zoom in. January 1st, 2021, a defense expert to be given to the state within 30 days. Plea deadline date, February 12th, 2021. Motion denied on the 702-705, that was denied. Motion to suppress statements denied. Then we come back on April 9th. Then we're back on April 9th for jury trial. Then as we know, we have issues because the state says they have some witness that they've discovered all of a sudden who's out of town. Somehow they find him, they get him served, get him attached, get him here. Then we come back on May 21st. Then we're back on July 12th. And then we're back on November 1st for jury selection of 2021. Then we go through all of this, and then there's a witness, there are videos, phone dumps that the state doesn't have. Or that the defense doesn't have because the state hasn't, the state didn't know they have it, it hadn't been turned over. So that's where we are, and that's what we have. So he's entitled and he should be getting a bond reduction. And the reason why he's going to get a bond reduction is because this trial should have happened. This trial should be over. It's not over. It didn't happen because the defense, even though we've gone since 2015, they haven't received documents they're supposed to have received. And we all know it wasn't done in bad faith. I believe the defense said they didn't believe it was done in bad faith, but they don't have the documents. So everything that people are presenting to me, I've heard it partway through the trial. So the only issue is, what should his bond be set at? And the court knows the law on setting bonds. So state, you're asking that the bond be cut in half. Please explain to the court why it should be in half. Why shouldn't it be $100,000? What is the magic number for $350,000? And I'm going to ask the defense the same question, by the way. But what is the magic number with $350,000? Why not 200,000? Why not 100,000? What are we trying to accomplish with this defendant's bond? Are we trying to accomplish that he is to remain in custody? Or are we trying to make the bond high enough where it will be a detriment for him to violate bond conditions? If that's the issue, because what I can tell both parties, when the court sets his bond, he is going to be on GPS. So, state.
Your Honor, the state's intent and only intent is to give due consideration to the aggravated circumstances of this offense and the relationship of this defendant to the deceased party in this offense. That is all. It is my opinion that when a senior citizen, a relative of the defendant, is found beaten, and the defendant is then found at the time the body is moved to the medical examiner's office using 2 of her credit cards in front of a video and immediately identified by family that know him, that outrage itself is sufficient. As to the amount, I take the court's point because we're trying to put a dollar amount on behavior in an offense. I picked 350, it was halfway down. From my review of similar offenses, murders, I've seen where bail has been granted in the amount of 100 to 150. So there can be grounds between that and the 350,000 that I've asked for. But my only intent is recognition of the allegation of this crime as charged. And none of the undiscovered evidence has affected that. Counsel even made it in his own argument.
All right, defense.
We respectfully disagree with everything he just said. His facts are wrong. There's no evidence that my client ever used a card. If there is, then that's more stuff they have not given to us. Now, the bond, the first thing you should consider is potentially now his actual innocence. So they have evidence that perhaps he didn't even do this and want to set his bond at $350,000. What would deter him from running? $5. He has no money. He's been in jail for 2,123 days. He's not going anywhere. He has nowhere to go. He has a wife and a mother-in-law that come to, and the court knows she saw them in court every day sitting behind us. He has people in the community that will help him and give him a place to live. But if the purpose of the bond should not be to keep him in jail and to say, well, to set his bond at $350,000 because we believe that's not oppressive, that's humorous. That's incorrect. We're asking you to set the bond at $1,000, which to some people in this courtroom may not be a lot of money. To the gentleman in the red outfit who's been wearing that for years, that's a hell of a lot of money. That is an oppressive amount of money for him to lose when you have nothing, absolutely nothing. So we believe that amount is proper. We disagree with his recitement of the facts, especially considering now the actual innocence potential based on their failure to disclose evidence of the real killers until a week and a half ago. So we're asking you to set it at $1,000. We believe that is justifiable and reasonable in this particular situation. We realize it's unusual, but so are these facts. Thank you for your consideration.
Thank you. All right, this is what the court is going to do. The court will set the bond at $50,000. Place the defendant on full GPS. The fees will be waived. To the defense, if the court is always open to reconsider that bond amount depending on circumstances. But however, for now, the bond will be set at $50,000. And the defendant is to be placed on full GPS. And if the defendant does have employment, then of course, the court will reconsider full GPS. All right, where are we on the defense being given hard copies of all of the state's discovery?
Your Honor, we're starting the reproduction and copying of those materials today.
When is that going to be done?
My objective will be to get it done by the end of the day, Your Honor, at a minimum by tomorrow. I will be in communication with counsel when it is complete to effect transfer.
All right, are parties available on December 2nd?
I'm not. Let me check with Mr. Langlois.
Well, I want all parties to be available.
I'm not here the second. I would be here the following week.
All right. All right, are all parties available December 9th?
Yeah, Judge, I'm flying out to Nashville that day for a wedding.
Okay.
9th. I'm okay.
December 9th is good for the defense, Judge.
State, are you good for December 9th?
I'm available, Judge.
Yes, Your Honor.
All right, so this is what's going to happen. All parties are going to be here on December 9th at 9 a.m. State, I expect the defense to have all discovery. So if you all want to discuss whatever phone dump hasn't been done or may be out there, whatever video that you may have that you may not know you have, everything needs to be given to the defense. Is there anything else from either side?
Yes, Judge. At this time, the court yesterday denied our motion for dismissal with prejudice. We're asking the court for a findings of fact and conclusion of law, a written finding of facts and conclusion of law regarding yesterday's findings.
All right, anything else from either side?
Yes, Your Honor. Along with the full GPS, the state would ask the defendant the court impose no contact with the family of Brenda Boyd, any member of the family or household, and I can provide the court office with appropriate addresses right after this hearing.
All right, so you're saying the family of her household because the family is the defendant's wife and mother-in-law. So you're excluding them from this, correct?
No, sir. No, Your Honor. I'm talking Brenda Boyd, the defendant's aunt-in-law, daughter of the deceased.
Okay, so I'm just trying to make the record clear. So the people that you want him to be excluded from contacting is not his wife or his mother-in-law, correct?
Yes, ma'am. That is correct.
All right, Mr. Curtis, do you understand that?
Yes, ma'am.
So you're not to have contact with the complainant's family outside of, I'm assuming, your wife and your mother-in-law.
Yes, ma'am.
Is there anything else?
No, Your Honor.
Not from the defense, Judge.
All right, and state if you will provide a list of the names that you are requesting that the defendant not have contact with to the state, and you all both can send it to me in a joint email, and I will add that to the court's order.
Yes, ma'am.
All right, with that, we'll close the record. Defense, do you need to speak with Mr. Curtis?
Yes, please.
All right, so if everyone can please clear the courtroom. That includes everyone, not just the state. All right, Mr. Curtis, I'm going to send you to breakout room number 1. In courtroom, I'll send you to 1. Michael Sawyer, who are you here for? You're on mute. Okay,
Fine, Judge. It's a family violence case, Matthews. I'll pop into a breakout room with him.
okay.
Your Honor, I'm unmuted now. I'd like to confer with the state this announced. We get together and talk about it right now.
All right, I'll send you to number 3.
And Judge, how are you this morning?
Oh, I'm doing great. You know, it's a beautiful day. Finally get a chance to wear a sweater. So I guess fall is upon us.
You have the right attitude.
All right, thank you. All right, Clerk Courtney Hilliard and Mr. Featherston, unless you have something else with us, you and your client are excused.
Okay, thank you, Judge.
We go breakout room 3, Valerie.
Thank you.
Good morning, Your Honor. It's Kelly Green.
Yes.
I'm here on Mallory Garraby, and I was court appointed. However, my husband was retained by her ex-husband several months ago to represent him in a child custody matter against her. So I'm going to have to ask the court to withdraw due to a conflict of interest.
All right, we will make sure she gets another attorney.
All right. May I be excused?
Yes.
Thank you. Happy
You're welcome.
holidays.
Oh, happy holidays to you. Norma, if you can assign another attorney based upon conflict of interest.
Yes, ma'am.
Thank you. Donald Wilson.
Morning, Judge. I've conferred with Marcus and with Mr. Kochanski. Marcus indicated to me that he has not been able to reach the victim in this case, and he was wanting some time to do that. I'm not opposed to that. And so he's not able to give us an offer until he makes some kind of contact.
All right, Norma, on Anthony Kochanski, can I have a 30-day reset, please?
Yes, ma'am. Let's see. We'll bring it back on.
All right, we're going to come back on January 16th.
Oh, sorry. Judge, I'm sorry, I meant January 6th.
All right, we're going to come back on January 6th.
All right. Thank you, Your Honor.
You're welcome. And where's your client?
He's in custody. He's on.
All right, I think you left him in a breakout room.
No, I see him. He's here.
All right, Mr. Kochanski, we're going to come back on January 6th. Norma, you can let them know he can go back. He's 16B. All right, thank you, Mr. Wilson. You're excused.
Thank you, Your Honor.
Rick Ramos.
Hey, Judge, we wanted to see if we'd be able to get you in a breakout room here shortly. Marcus Sanders and I, when you get a moment, Your Honor.
All right, which room are you all in?
We were in room 5, Your Honor.
All right, I'll meet you in 5.
Thank you, Judge.
Brenna or Norma, can you let Mr. Langlois know he does have David Aguirre on the record, on the docket as well? Thank you. All right, LG style of 6, is that you, Mr. Marino? All right, can you unmute? All right, Mr. Marino, your attorney has already come in. You're going to come back on December 14th and you'll need to be in the courtroom, okay?
Okay, ma'am.
All right, and that'll be at 9 a.m. It's the 187 District Court, all right?
Okay, ma'am. Thank you. God
You're
bless you.
welcome. Oh, thank you. Mr. Cox? All right, to the Criminal Trial Division prosecutors, Mr. Cox is in breakout room number 4 on Raymond Amaya. All right, Mr. Sawyer.
I am back.
Okay. Yes, what's happening?
Your Honor, we are conferred with the district attorney. I will be filing some preliminary motions, most importantly, a motion for a complete psychiatric workup of my client. There's also some discovery that will need to be done personally with the DA in their office, which I'll set up next. At least this way we get our conversations off the ground.
Okay. All right, Ms. Ferguson, can I have a 30-day reset on Matthews, please?
Judge, that would be fine, 30 days.
All right, thank you.
Judge, thank you very much and have a good day.
Oh, wait, let me give you a date.
Yeah.
Your new date is going to be January 6th, 2022 at 9 a.m. I'm still having a hard time saying 2022.
It doesn't seem real, does it?
No.
And can I go to a breakout room with the defendant, Myron
Yes.
Matthews?
All right, Mr. Matthews, I'm going to send you to breakout room number 6. And Mr. Sawyer, I'll send you to 6.
Thank you, Your Honor.
All right, have they finished speaking with Mr. Curtis? Norma, can you let them know that Curtis can go back? He's listed as number 12.
Judge,
Yes.
if you want to do Mr. Gary, we can do that real quick. It's a motion to withdraw at his request. And he indicated that he didn't want me and he's gonna hire another lawyer. And that
All
was-
right, Mr. Gary, can you unmute yourself, please?
Yes, ma'am.
Yes, according to the agreement is you entered a plea of guilty to count 2, show up for court.
Yes,
So
ma'am.
today we're doing sentencing.
I was, I had somebody coming in, for, as far as a witness, to say that it's not my stuff. It was a person that
No,
delivered.
no. You entered a plea of guilty to count 2. You were supposed to show up for sentencing and you did not show up. You've been missing since May 13, 2021. So we're here today for sentencing and that's what's going to happen today.
So I don't get a chance to have this personal affidavit.
What I'm telling you is you're here for sentencing. That's what we're doing today.
Well, I'm not ready for sentence.
All right, is there someone from the state present, please?
I would like to take it to trial.
Is there someone here from the state, Marcus Sanders, please?
And also my court appointed, the lawyer that hired Mr. Lengua trying to say that I fired him. I never.
All right, is there anyone from the state to take this sentencing? According to the plea bargain agreement, punishment was to be assessed at 5 years. Is anyone available?
Judge, I can stand in.
All right, thank you. Court is calling 2021 CR 0394, State of Texas versus David Medina Aguirre. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
And are you, and Mr. Langlois?
Judge, I'm in court for Mr. Gary.
Okay, there we go.
I can't hear you, Mr. Langlois. What did you say?
I'm sorry, Judge. I'm in court and I'm present. And
All right.
The
The defendant entered a plea on April 9th, 2021 to count 2. He entered a plea of no contest. The state waived count 1 and the enhancements without objection. According to the plea bargain agreement, the defendant is to be sentenced to 5 years. The court will follow the agreement. And as previously stated, on April 9th, the court found there was sufficient evidence to find the defendant guilty, and the court is finding the defendant guilty and did find the defendant guilty. Court will follow the plea bargain agreement, sentence you to 5 years in prison. Taking consideration 2021 CR 0315, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal, Mr. Aguirre. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you need to know the definition of what a weapon is, you'll need to contact an attorney to do that. Good luck to you, Mr. Aguirre. Thank you, Mr. Langlois. Norma 17D can go back.
May I go, please, Your Honor?
Yes, have a good rest of your day, Mr. Langlois.
All right, thank you.
All right, Rebecca, did Mr. Radon Marshall ever come?
He did when you were in RC Curtis, so I just transferred us and I already did what I needed to. Thank you.
All right, thank you. Mr. Cox?
Good morning again, Judge. Yeah, I confer, Judge, and it's a lot of discovery that the state is still waiting on. uh, some is Instagram, some buckle swabs. So it's a lot of information that's still waiting on this. So we're gonna need a just reset it. The case has just been indicted. So
All right, Ms. Ferguson, can I have a month reset date for Amaya, please? And Mr. Amaya, you want to unmute yourself?
Hello,
Hi, how old are you?
I'm 19.
All right, so here's the thing. You're 19 years old. This is a serious situation. You're in courtroom. I don't know who you're laughing and joking with, but you're charged with an aggravated robbery. The range of punishment for that in the state of Texas is anywhere from 5 to 99 years or life. So this is a serious situation. Do you understand?
Man, my apologies.
All right, and if there's more inappropriate and immature behavior on Zoom, your Zoom privileges will be revoked and you will be required to appear in court. Do you understand?
Yes, ma'am. My apologies again.
All right, we're going to come back on January 6th, 2022.
Okay.
January 6th. Okay.
Can you believe it's already 2022?
Can you believe it's January 6th? That'll be the anniversary from the insurrection, Judge. So
Oh my gosh, I could, yes, okay.
some things you just kind of remember. Yesterday
Yeah.
was November 22nd, Judge.
Okay, yes.
I had to play my tapes of the assassination. But anyway, you have a good one. Happy Thanksgiving to you and yours. And we'll see you
All right,
on
happy Thanksgiving. I'm shocked you were not in Dallas this year.
in Dallas, Judge. Well, I wasn't there physically, but mentally, I was at the grassy knoll, Judge. At the grassy knoll.
All right, have a good one.
All right, take care, Judge. Thanks.
All right, bye-bye. All right, Norma, the attorneys we're waiting on is Joseph Acevedo. Juan Ramos is in a breakout room. And we need Alfonso Otero, Ed Piker, and Jay Norton.
Judge, did we hear from Robert Maurer?
No, he hasn't come in yet. Giving. Joseph Acevedo?
Yes, Your Honor.
Yes, who are you? You are here for Mr. Small?
Yes, Your Honor. Yes, Your Honor.
Okay. I'm going to send you to breakout room number 3.
Thank you, Your Honor.
You're welcome. All right, Mr. Acevedo,
Good morning, Judge.
good morning.
Judge, I've been out with the loss in my family, and I haven't had sufficient time to visit with Mr. Small.
Mhm.
Would you grant me a reset so I can bring him into my office and visit with him?
Okay, when are you going to be back?
I am actually out through all of December, but if you just give me a couple of weeks so I could at least bring him in and visit with him.
No, I'm just asking, when are you gonna be back?
I am back already, Your Honor. I am back.
No, I mean, but you said you are leaving, so when are you leaving?
No,
I'm trying to
just,
figure out what your schedule is so I can
no,
give
what I
an
was,
appropriate date.
what I was referring to is I'm unavailable till the new year.
Okay. So what does that mean? So are you gonna be back?
January
Sorry?
2nd, January 2nd, Your Honor.
All right, and do you know, is this going to be a contested hearing or not?
I don't know that. We've conferred. There's a couple of more things we're trying to find out from the CLO because it was recently transferred. I don't know that offhand. But
Okay.
if you want to put it on that, so be it.
All right, because what I'm looking at here is they're having the defendant, he's not available for random field visits. And Mr. Small, I'm not taking it in this as true. I'm just telling you what's in the motion to revoke. They're saying that you haven't done drug testing, you haven't reported for August and September, you're not abiding by the random field visits, and you haven't provided proof of employment or a doctor's note, and you haven't been doing your virtual reporting. So here's the thing, Mr. Small, I'm not taking any of that as true, but you had better allow them to do their random field visits and you better get in line. You understand?
Yes, ma'am. The last probation
Yes, Your
officer I
Honor.
had,
Mr. Small, Mr. Small,
No. I'm just telling you, you need to get in line. You
we're going to
understand?
visit on that.
All right. Norma,
Okay.
so Mr. Acevedo, are you out the remaining of November or no?
I only have the 29th and 30th, but that doesn't give me sufficient time to, and then I'm out through December.
All right, Norma, on this case, can you set it for a contested hearing at the beginning of January, and no further resets are going to be allowed, Mr. Acevedo?
Yes, Your Honor.
All right, we're going to come back on January 5th for contested.
What time, Your Honor?
9, what time, Norman? 9 a.m. or 2 p.m.? All right, at 2 p.m. Mr. Small, you need to make sure that you are in the courtroom. The court is located at 300 De La Rosa, 187 District Court on the 4th floor. Do you understand?
Yes, ma'am.
And the other thing that's going to happen today is you're going to do a UA today. And that UA
Okay.
needs to be done by 1 p.m.
Yes, ma'am.
Rebecca, do you need to go into a breakout room with him to tell him where to take his UA?
Yeah, I want to make sure he has the address.
All right, so you're going to do a UA. If you're employed, you're going to get that information to the probation officer before we come back. And if there's some issue where you were supposed to give him a doctor note, you're going to have that doctor's note. Do you understand?
Yes, ma'am.
And you had better start appearing for your reporting days. Otherwise, you're going to be reporting in person and not by Zoom. Do you understand?
Yes, ma'am, I do.
All right, so we're going to be back here on January 5th at 2 p.m. That's going to be in person. And you're going to go take a UA today.
Yes, ma'am, I'll do that.
All right, and what are the results of the UA going to be?
They're gonna be clean.
Okay. Rebecca, I'm going to send him to a breakout room with you. I'm going to send him to breakout room number 3. Mr. Acevedo, you can go to breakout room number 3. Then you and your client are excused.
Thank you, Your Honor. Have safe holidays.
Thank you, you too. Rick Ramos, let me check to see if I have all your paperwork. Has your client been sworn in?
Judge, we haven't signed the paperwork. I actually need something from the clerks regarding the consent to plea and the appeal paperwork.
All right, Ms. Ferguson will get that to you.
Thank you, Judge.
You're welcome.
No, I forgot to let you know. And Rick, I'm still doing mine also.
No problem, Marcus. Thank you.
All right, Mr. Maurer, you're here on,
Antoinette Garnica, Judge. It was just a travel request for Thanksgiving tomorrow. And I think if I can find my motion, it's for in-town travel. She's not planning on leaving San Antonio. She has 2 relatives' houses she wants permission to go to.
okay. And is this criminal trial division or family violence?
Judge, I think it's family violence.
All right, is there a family violence prosecutor available on Antoinette?
I'm here, Your Honor.
All right, I'm gonna send you both to breakout room number 1. And so, Mr. Maurer, if you'll go to 1 and see if you all can reach an agreement. And Ms. Hayden, do you have the motion for request for travel? Hopefully she does.
Judge, can I report back when you have a chance on my issue?
Yes.
I've talked to Michelle. She's okay with my lady's travel request. Just she's going to 2 different addresses, both in San Antonio for Thanksgiving. The times are specified in the motion in the order.
All right, the addresses I have are in the motion are Bernard Street and Mulberry. Is that correct, defense?
Yes, ma'am.
All right, then the court is signing the order.
Thank you, Judge. I appreciate it.
Thank you. Have a great
Have a good Thanksgiving.
Bye-bye.
You too. Bye-bye.
Ms. Garnica, you're
Yes, ma'am.
excused. Happy Thanksgiving.
Happy Thanksgiving and thank you so much, Your Honor.
You're welcome.
Goodbye.
Bye-bye.
Have a good day.
All righty. Are the parties ready on Joshua Howard?
Yes, Judge.
Let me see where the attorney is. And I'm sorry, Alfonso Otero?
if I just sell tickets to like drive by my house and you can get out and like,
You're here for Brandon Hernandez. And
yes,
that's,
Judge, I haven't heard from him.
he's in the courtroom.
He's in the courtroom. Okay.
Yes. I'm gonna
So
send
if
you
I
to
may-
break. I'm sorry, yes?
If I may talk to any prosecutor about the case, because I haven't
Yes.
conferred with anyone.
I'm sending you to breakout room number 1. A prosecutor will meet you there.
Okay.
And I'm just waiting for the defense attorney on Joshua Howard. Who is that?
Am I announcing Tom Nisbet for the state?
Oh, no, we're trying to find the defense attorney, unless you're gonna be defense in state.
Oh, Your Honor, Thomas Healy for defense.
All right, let me see, who is his attorney?
It's Thomas Healy.
Okay, well, we don't know where Mr. Hilly is. We're gonna take care of you, Mr. Howard.
Judge, he's on a Zoom in Del Rio doing the sentencing.
Okay, so Mr. Howard, we're gonna get to you. Don't worry. Brenna, it's a Monday, but it's a happy Monday. Everyone is excited about the upcoming festivities. Brenna, I don't know if my students will be happy because their upcoming festivities is their final exam. So, but they should all be prepared. All right, everyone, just give me a moment.
I'll be right back.
All right, are we, Thomas Hilly?
I'm ready whenever you are, Your Honor.
All right, we're ready.
I just finished the federal sentencing in Del Rio, but I'm ready now.
Okay. Who is the prosecutor?
Oh, I talked to Mr. Thomas, but Mr.
Is there a prosecutor available to do the plea?
Yes, Judge.
Thank you. Not gonna happen. All right, the court is calling 2021 CR 9762, State of Texas versus Joshua Wayne Howard. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Thomas Hiller, ready?
And are you Mr. Howard? Can you unmute for me, please, sir?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
None.
Any objections from the defense?
No, Your Honor.
Mr. Howard, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it?
Yes,
Did
ma'am.
you electronically sign it?
I did. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Howard, I'm showing you what's entitled a application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? And
I
you
did.
sign
Yes, ma'am. I did, and I signed it.
it? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Howard, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Judge.
Mr. Howard, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
I did. Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am. That's correct.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Howard, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,500 fine. State recommends deferred adjudication, and there is to be $57 to SAPD for drug testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, to all three. Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 80 hours of community service, restitution, and proof of employment. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I put guilty, ma'am.
State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No, Your Honor.
Mr. Howard, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you
Yes.
electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Nope.
Court will find that defendant has knowingly and voluntarily waived and consented. Oh, I'm so sorry. No. The court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
He explained to me that he is confident that he can accomplish all the tasks of the deferred in 2 years, Your Honor.
All right, Mr. Howard, how often have you been using?
Well, I've been here since, well, going on almost 4.5 months, I believe. It's been quite a while, and I don't use that often. And I hadn't, but
Well, how often do you use?
maybe 2-3 times a week. It's rarely, that's not a very habitual thing for me.
All right, that's a lot, 2 or 3 times a week.
I
I mean, in the big scheme of things, it's a lot. That means that you're high 3 days out of the week.
yeah, I was at, in the past, yes, that, yeah.
So when did you start using?
Maybe, well, it's been a few years back, and it's not a consistent thing. It's kind of fluctuated with, the work where I'm living,
So what's the first time you used? How old were you?
Maybe 4 years ago, I believe.
So how old were you?
That would have made me 38.
Right. So why would somebody who is 38 all of a sudden start using meth?
The girl I was dating at the time did.
Oh, okay. Well, you know what? It's never somebody else's fault. I
Oh,
mean,
no.
unless she forced you to use it.
And she didn't, and I'm not with her anymore either. So
How old was she?
about 4 years younger than I.
Okay. So what's up with all the tattoos?
An expression of an inward person outside.
No, I mean, what are the tattoos?
Well, I have a black cat. Pretty much my thumbing my nose at luck. I always have a black cat crossing my path. And I have a dragon and a tattoo, kind of the duality of man.
All right. And what are the other tattoos?
I have a nautical star and 210, which is, of course, San Antonio.
All right. So why do you need 210? Do we
What's-
not know the
No,
area
it's
code here?
no, it's that, I'm from here. I was born here, more or less. I was raised here. It's
Have you ever been to prison before?
no, ma'am,
Any gang affiliations?
none whatsoever.
All right. Brent, I never understand why people put area codes on their body. It's like I need to remember my area code. I don't know. So what's the last employment you had?
I was working at 84 Lumber through a temp agency when I was actually leaving work when I got picked up and put in county. And I really enjoyed the job, and hopefully I can still go directly back to it.
Do you have any children?
No, ma'am, I don't.
Okay. Where are you going to be living?
Well, I currently was with, again, I've been here 4 months, and I haven't been able to reach anybody in the free part of the term, but I was staying with my friend, and my mother lives here in town as well, and I mean, that's not going to be a problem. I'm not going to just be wandering the streets.
All right. Does your mother want you living with her?
I haven't spoken to her about it, but yeah, I mean, we're very close. I mean, I just don't like living with my mom. I mean, I'm 42.
All right. This is what the court is going to do. $1,500 fine. That'll be probated. 3 years deferred adjudication. $57 to SAPD for drug testing. Random field visits. Two times per month. UA hotline. Are you able to Zoom?
I would assume so. I'm with Metro, so I mean, once I get out and pay my bills, and yeah, I would assume so.
All right, there's to be regular Zoom reporting. If you can't report by Zoom, then it'd have to be in person.
Okay.
Proof of employment within 15 days of release.
Okay.
No employment as a home health care provider or with minors.
Yep.
80 hours of community service restitution. 40 of those hours will be waived if you provide proof that you've taken the COVID vaccination. That includes the entire regimen. The court is not forcing you to get vaccination. That's completely up to you. But if you do get it, 40 hours will be deducted. Intensive outpatient treatment with probation. And Rebecca, once he's in outpatient treatment and intensive outpatient treatment with probation, then he can switch to random UAs. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Howard, anything else you need from the court in order to be successful?
No, ma'am. I'm very confident in myself. Thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. If there's nothing else, we'll close the record.
Okay.
All right,
And
Mr. Howard, how old are you?
42.
All right, Mr. Howard, you're 42 years old. I mean, you're past the point where you should bend to peer pressure, be the peer pressure from a girlfriend or whomever it may be. You're old enough not to bend to that. You're getting to the point in your life where you're going to have more of your life behind you than in front of you.
Understood.
Unless you're planning to live to be 160 or 200.
One can
I mean,
only hope.
it could happen, but you're going to have to get your life together. You understand?
Yes, ma'am, I do. Very much so.
All right, good luck to you. I'm going to send you to breakout room number 2.
Okay.
I'm sorry, let me send you to 3, and probation will go over conditions with you.
Yes, ma'am.
And if someone is available to speak to Alfonso Otero in breakout room number 1, please.
Thank you. Maybe Susan.
Yes.
Thank you. Thank you.
All right, Mr. Acevedo. You have someone else with us.
Yes, Your Honor.
Just one second, let me find it on the docket. But did you see the other case that Mr. Acevedo had with us? It was a motion, actually, Mr. Acevedo, it was a motion that you filed. Let me see if I can find it. All right, Mr. Acevedo, you filed a motion on Gregory Montemayor.
Yes, Your Honor. A motion to travel?
Yes, so I'll let you confer with the state. Is there anyone available from the state? I'm gonna put the cause number in the chat box.
Judge, this one is David Lunan. It's his case.
Norma, can you see if David Lunan can zoom in or someone?
The name of the defendant? I'm sorry.
It's Gregory Montemayor.
Oh, probably not, but let me, probably not an agreement, but let me get with David.
All right, thank you. And he wants to leave for Thanksgiving on the 24th at noon and return on the 27th.
Okay.
And he's on GPS.
Tracking.
Yes, yes.
Jacqueline sent this saying,
David says it's fine.
Okay. All right, Mr. Acevedo. The motion has been signed. Oh, you're on mute.
Thank you, Your Honor. Have blessed
You're welcome.
holidays.
All right, thank you, you too.
Could, Deputy Lark, can you go to the breakout room 1 so that Brandon Hernandez can speak to his attorney?
okay, just
I'm sure. All right, are the parties ready on Ira Williams?
Defense is here, Your Honor. I don't see Mr. Sanders.
Okay, I think he's in breakout room number 1. Do you have those dates, Mr. Ramos?
I do, Judge.
And what are those dates before we go on the record?
Those dates are going to be, let me just pull it up for you. I have it written down here, Judge. It's on the plea paperwork as well. It will be on the plea bargain paperwork, Your Honor.
All right, let me check the plea bargain paperwork. Just 1 second. All right, is it from August 18th, 2019 through February 6th, 2020 and March 4th, 2020 through July 8th, 2021?
That's correct, Your Honor, as well as his Bear County time.
Okay. All right, is there a prosecutor available to take this plea? Hunter? All right, the court is calling 2019 PR 7692 State of Texas versus Ira Williams. Can I have parties announced for the record for the state?
Tom Nisbet.
For the defense?
Rick Ramos.
And are you Mr. Williams?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No.
Any objection from the defense?
No, Your Honor.
Mr. Williams, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review that discovery with your client?
Yes, Your Honor.
Mr. Williams, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're waiving the enhancement allegation. Is that correct?
Yes, Ron.
Right. Court will find that defendant has knowingly and voluntarily waived his right. I'm sorry, consented to his right to appear in court. The court will find that the state is in compliance with discovery. Mr. Williams, I'm going to show you what's entitled Court Admonishments to Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand that what you're charged with is possession of controlled substance, penalty group 1, 4 grams to 200 grams, and a second-degree felony?
Yes, ma'am.
The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, I'm sorry, Mr. Williams, we're having problems hearing because it appears somebody is just chatting behind you.
I'm sorry about that.
Oh, no, it's not your fault. I think that's the deputy chatting to somebody. All right. If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
According to the plea bargain agreement, your punishment is to be assessed at 4 years in prison, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you, and this is not really outside the plea bargain agreement, but it's placed outside the plea bargain agreement because there is not room above the line for it. But of course, the court will give you credit for each time served in Bexar County Jail. And both the state and the defense agree that you're entitled to credit served in Cameron County. Both the state and the defense agree that you are to receive credit for time served in Cameron County. Those dates are August 18, 2019 through February 6, 2020, and Atascosa County. And those dates are March 4, 2020 through July 8, 2021. Did you understand that that is a part of your plea bargain agreement as well, Mr. Williams?
Yes, ma'am.
Defense, did the court correctly give the times for his credit?
Yes, Your Honor.
Then to the offenses charged in indictment, how do you plead? Guilty, not guilty, or no contest? Mr. Williams? You're on mute.
Yes, ma'am. No contest.
State, any evidence to support the defendant's no contest plea?
State offers exhibit 1 and attachments.
Objections, Your Honor.
Just 1 second. Who's talking over there, Mr. Williams?
She can hear y'all in the background. She said,
Yeah, no problem.
Yes, and profanity is being used.
and she said profanity has been used. Please cut it.
Okay, they're sorry.
They said, sorry, Judge.
All right. So state, any evidence to support the defendant's no contest plea?
We offer exhibit 1 and attachments, Your Honor.
Any objections?
Objections, Your Honor.
Mr. Williams, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Off the record, Mr. Parker, if you go to breakout room number 1, please.
Yes, I will. Thank you.
State, it is a criminal trial division case.
You can't fight time. For instance, the guy next to me, the one that, you know, what I mean, I'm looking at him like, a lot of people take it like a game, right? Because so to say, life is a game, it's just how you want to play it. Right? There's a lot of metaphors for what for life. And I'm looking at him, really like, you know, there's no structure, there ain't no respect.
I'm gonna call again to see if he wants to give a statement.
I know it wasn't like that, you know. You don't have any morals, you know what I mean?
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court then will follow your agreement. The court will sentence you to 4 years in prison, give you credit for any time served in Bexar County, credit for any time served in Cameron County. Those dates are August 18, 2019 through February 6, 2020. Credit for time served in Atascosa County. Those dates are March 4, 2020 through July 8, 2021. Is there anything else from either side with regards to sentencing?
Nothing from the defense, Your Honor.
Mr. Williams, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with the attorney? Did you understand it? And did you
Yes.
electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what the definition of a weapon is, you'll need to contact an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Williams, we'll go off the record. Good luck to you.
Thank you.
How old are you, Mr. Williams?
47.
You've heard the speech. You're getting to that point in your life where more of your life is behind you than in front of you.
Yes,
And your
ma'am.
question is, do you want to spend the rest of your life in and out of jails, in and out of prison?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
All right, you're welcome. Have a great Thanksgiving.
You too, ma'am.
All right, bye-bye.
Bye.
Can you let them know that 14-0 can go back?
May I be excused, Judge?
Yes.
Yes, ma'am.
Thank you, Judge.
Alfonso Otero.
Yes, Judge. I spoke to Marcus. We have an agreement on Mr. Brandon Hernandez. We're preparing the plea paperwork, but I was going to ask the court if we can come back maybe in the afternoon. The reason is that my mom is flying in and I need to go pick her up at the airport.
All right, when is she getting here?
She's supposed to get here at noon.
Well, you're late.
Well, I'm
Are you
right.
going to leave your mom at the airport?
No, that's not a good idea. But yeah, she should be there. I'm about 2 miles from it. If we can do that later today, I'll really appreciate it. If there's no other way, I can just try to send somebody.
Well, I mean, what kind of son would you be if you sent somebody to maybe pick up your mom from the airport?
Say that again, Judge.
I said, what kind of son would you be if you sent somebody, find somebody to pick your mom up to the airport and she's expecting you?
A very bad son, Judge.
Yeah, it won't be a happy Thanksgiving for you.
I believe it will never. Yeah, she never forgive that.
Moms always forgive, but I don't want to be the cause of your mom having to forgive you, or the fact that if you don't pick her up on time, that's going to be brought up at every Thanksgiving.
Thanks, Judge.
All right. So the court wasn't planning on being back at 2, but here's the thing. You need to be here exactly at 2.
Yes, Judge.
Okay. All right. We'll see you back at 2 p.m.
Okay. Thank you, Judge. May I be excused?
Yes. Guys, I know we were intending not to be back at 2, but it's the mom. All right, and has anyone had a chance to confer with Mr. Piker in breakout room number 1? He's on 1 mellow. And Norma, in the courtroom, we need an attorney appointed for Kelly Green's former client.
I already sent it to Norma Lotta, Judge. She gave it to her already.
All right, thank you. So when is that case coming back?
I'm gonna go to your office in just a few minutes, Judge.
All right, thank you. Jason, Goss,
Yes, Your Honor.
hi, have you been getting any sleep?
No, not at all.
Norma said that's gonna happen for the next 18 years.
Yeah, I've started on that road and it's a hard one.
Oh yeah, babies will run the household.
Yes.
All right, I'm gonna send you to breakout room number 2 and a prosecutor will meet you there.
Okay. Thank you, Judge.
Sure.
Hmm.
All right, Mr. Piker.
Hi, how are you?
Great.
I got Juan Mello. I'm not sure if he's on or not. We emailed him, but it came back as a failure and we've called who we could call. So he hasn't returned that call, but so I don't know if he's on or not. I did confer with Mr. Sanders. They're trying to contact the complainant.
No, he is not on, but they told me in the courtroom that he always appears.
Oh,
So what we're going to do is I'm going to recall this. Norma,
Yes, ma'am.
can you put Mr. Piker's client on for the last week in November?
Yes, ma'am. I can do December 3rd.
hold up a second.
No, are we able to do the 29th of November or no?
Yes, ma'am.
Judge, just so you know, I've got 7 Zooms scheduled already on the 29th.
All right, Norma, can we do the 30th?
I've got 5 that day.
I mean,
I know, I'm just saying.
I understand.
I can do what I can do, but I want you to know that I may be very late doing it.
All right.
And then December 1st is a civil trial. The whole next week is just ridiculous. December 6th, I'm wide open.
All right. We're going to come back on November 30th. And please get in contact with your client. Make sure he's here.
You want him there in person?
He either needs to be in person or on Zoom.
Okay, very good.
All right. Thank you.
All right, thank you. Have a nice holiday.
All right. You too.
You bet.
Everyone, we're going to take our break and we'll be back at 2 p.m. So we'll be back at 2, everyone. Mr. Flores will be back at 2. Oh, you're on mute.
I said, that's okay, Judge. Take your time. I'll be back.
All right, thank you. We'll use this same Zoom link.